Hi, this is Tina with Siebel HR Consulting. I'm here today to give you guys your 2021 updates for California law. There's 6 total areas I want you guys all to be aware of. The first one is called CFRA, and that protects employees for 12 weeks of family care or to care for themselves. And there were certain guidelines that they had to meet. It was 50 employees within a 50-mile radius, no longer 50 employees, and there's no radius whatsoever. So if you have 5 W-2 employees in California, you now need to allow employees to take up to 12 weeks of protected time off. Remember, this leave does not pay them. It is for job protection only for that total of 12 weeks. And it does sometimes run concurrently with the FMLA. The other area I want you guys to be aware of is King Care Act. You might have not heard of it called King Care Act. It basically protects parents up to 40 hours per year to attend school type of events. So if there was a parent-teacher conference, if there was some type of event that they needed to go to, they could use up to 40 hours throughout the school year or for the calendar year. And previous to 2021, employers had the discretion to tell the employee how to use that, but we're in California. So in 2021, that's changed. Now employees have the right to tell the employer how they want to take that time off. So if they want to use vacation time, they can use vacation time. If they want to use sick time, they can use sick time. So that's that change. The next change is for Victims of Crimes Act. So for any employee that's in a situation where they're applying for a TRO, or they need to attend court, or they need to go and down and file certain information related to certain crimes, they have protected time off for these situations. It usually affects people in situations of domestic violence, stalking, anything where they're a victim of a crime act, they have protected leave time off. Another area is severance agreements. So if you are issuing out severance agreements, and in that agreement there is a section that states that the employee can no longer work for that company or any of its affiliates. So if it was to get bought out by another company, they wouldn't be able to work for that new company. That section's got to come out of your severance agreements. If you're one of my clients, it's not in your severance agreement. The other area is Crown Acts. Crown Act became effective mid-year this year, and you need to be aware of it. It basically protects people from any type of discrimination with certain hairstyles. So when it talks about hairstyles, if you're not like, what does that mean? You don't understand it. It's protecting people of certain hairstyles, cornrows, dreads, locks. If they have colored hair, you cannot discriminate against someone because of their hairstyle. The other area, the last, which should not be a surprise to anyone, is minimum wage is increasing in California, and that means that for your exemption status, that hurdle, one of the hurdles, where they have to make double the minimum wage, that is changing as well. So if you have some employees that are barely making it over that salary hurdle, it's going to be even tougher now. You're going to have to increase them because the new annual amount is going to be $54,080. So if they're not meeting that hurdle, we need to go ahead and talk about making sure that they can get the increase, or maybe they don't make that exemption status. That's it for now. That's all your 2021 updates for California. Have any questions, please feel free to reach out to me, and don't forget to hit that subscribe button. Thank you.